council. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Judges, Chief Justice Simpson, last judges, but then these would be cases with simple matters, like individuals who want to bail at night because probably they have been in the bar, they have drunk a lot, and they want to bail. You rush to a judge's home or the chief justice's home, and you would grant a bail. It's a beautiful custom, beautiful practice, and I invite you to respectfully, my lords, that you endorse it in your ruling. It gave justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, still minors, in the West, our local girls, and you want now to fly out with these little children at odd hours. They want to get to work, they want to get to the ships at odd hours, and you rush to a judge at night, and he will give you an order, and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications, like telephone directories, their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and he would grant you orders. We no longer have that type of thing at all. I wish it could be reinstated. It was helpful if they handed down justice to the court. I recall one judge I appeared before, and I think he had me talking to his askaris at night. And he came out, shouted, "Who is that?" Somebody said, "Oh, it's Khaminwa. He wants to come and be heard." And they shouted at me and said, "Khaminwa, I want you to know I'm not a judge during the day. I can't hear you, the time is over." And I returned and told him, "Judge, the world will be shocked to hear, or the country will be shocked to hear. You are only a judge during the day, and at night you are not a judge." My Lord, let us reinstate that practice, say so very loudly in the ruling. But then, coming to some case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice, his powers are set out in Articles 147, 148, 149, 150, 151. He has enormous powers. If a person can become a president of the Republic at any time. If you're going to hear his matter regarding impeachment, you should hear it during the day, and it should be heard in the parties. It's not a matter that can be heard at all. What the Deputy Chief Justice or whoever it is would have done is to get on phone, to get in touch with the attorney general, get in touch with the advocates, and ask them, "Can you come?" But it should not have heard this matter at This is not a matter that can be heard at all. And then also, when you look at the Constitution, the Constitution seems to be very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. If you permit me just to read it to the court. It says that, not 165, Article 144, Article 4, Article 144, Article 4. It says that 144, Article 4. So sorry. Yeah, if you look at that 144 of Article 4, Yeah. If the, thank you very much. If the Chief Justice is unable to appoint a tribunal under clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly, Your Honor, where the Deputy Chief Justice can act, it is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer your Lordship to impeachment provisions relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is if you could look at Article 165, Article 4, 165, Article 4. 165 Article 4. It says that any matter certified by the court as raising a substantial question of law under clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the Chief Justice, he takes into account a number of things, my friends. You take into account the experience of the judge that he is appointing. You take into account things like whether it would probably bring a conflict of interest. You take into account whether there would be objections from certain individuals and so on, whether you not to do that at all. It takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated. The Deputy Chief Justice at all. It is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that, look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And they would probably say that, look, why don't you have so and so, so and so, so and so, so and so? And you would actually assign the judges to hear such matters. I would emphasize, and I also keep myself with my other friends, that there has to be a miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her. Not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind in law, the issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people calling together? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. They may come to the conclusion that, look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are giving matters to do with the administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the deputy president of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the deputy chief justice was probably preferred instead of the chief justice? Is it wrong people to probably to the chain when they're having their task and dealings that the deputy chief justice is possible that the deputy chief justice is taken because he's a friend of the deputy and such things and so on. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submissions of my ever-learning friends. There is a word somewhere in our safety in the Constitution that the deputy chief justice may perform functions today or the duties of the chief justice in absence. Clearly, that refers to cases where the chief justice may be relieved or the chief justice may be sick or the chief justice may be involved in something that is cannot enable to perform the work and so on. Now, in this particular case, nobody has alleged to the chief justice for anywhere. Nobody has alleged to the chief justice on duty, and nobody was alleged anything that made it impossible for the chief justice to carry out her duties at all. Again, I emphasize the question down on removal of the deputy president as Dr. And it's something that is making a number of Kenyans entertain us for interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current Now, you can't blame her when such things are happening. You can't blame her to have come to the conclusion that the Almighty God and the Lord Jesus Christ no longer supports the current government because of such things. I argue very strictly that you have forced a mission of my young friend, Mr. Kiwe, and his care colleagues. They are able to mission, and it is unbelievable. Thank you.
May it please the court. We will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, a very eminent Dorcas Wewe, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, sub-article 6 enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ongoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says the Constitution 2010 in many ways is transformative, has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power. What a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray, my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the drafters. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Gobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say, only they are entitled to ex parte orders. They are here to complain that they went before Judge Gobo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kiriboya is in the portal, unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the panelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Article 161, (2)(a) and (b), that establishes the office of the Chief Justice as head